Well, good morning. Today we're going to be talking about bullying, not specifically related to kids with disabilities, but there are some extra protections that we will talk about. So this could apply to any child who's dealing with bullying. We will also talk a little bit about what happens if your child is accused of bullying. So we'll talk about both sides of it, but mostly I just want parents to know what they can do if their child is a victim of bullying. Just some housekeeping, you know where the restrooms are, and if anybody needs any more water, let me know. So we'll just talk, our agenda will be, we're going to start with talking about the Massachusetts bullying laws. So you'll know where everything is coming from. The important definitions, there are three in particular that parents need to be aware of. What the school is required to do under the law, and most important, the practical steps for parents when it comes to that. Just a reminder that this is for informational purposes only. There's no attorney-client relationship. And at the end, we'll have an opportunity to ask questions. If anybody wants us to turn the video off at that point, I'll be happy to answer any questions that we can. As far as my background, I grew up with a sister with severe developmental disabilities, which began in the days before Massachusetts or anywhere had any legal rights for children with disabilities. And so I have witnessed my mom from that time to the current day even struggling with getting the appropriate services. I also have a child with a learning disability and grandchildren with learning disabilities. So I've had a lot of experience, personal and professional, with the IEP process, the 504 process. I've been an attorney since 1991. I have focused on special education since I retired from the state in 2015. I was a prosecutor from 1994 to 2015, and I have to say a lot of what I learned as a prosecutor has been very helpful to me in working in this area. I am a special education guardian ad litem appointed by the the juvenile court for children who are in DCF custody. I'm on the board of directors here at Jericho. And I am also a Human Rights Committee member for ServiceNet, which formerly was Pathlight in Springfield. So just to talk about the sources of the bullying prevention laws, because I find a lot of times what the schools do and what the parents experience is the schools will say, well, that's not our policy, or this is our policy. But what really dictates what is supposed to happen when it comes to bullying, as well as almost anything else in education law, it has to be in compliance. Their policy has to be in compliance with both federal and state law. Now, the federal law generally, there we go, comes under the Federal Family Educational Rights and Privacy Act, which is basically, we've adopted that in Massachusetts. There are federal regulations that interpret that Federal Education Rights and Privacy Act. But we look mostly to Massachusetts law. Massachusetts actually passed its first anti-bullying law in 2010. And you may remember during that time, around that time, here in Western Massachusetts, there were two very high-profile suicides of children who were bullied, one in high school and one in middle school. And so that really, I think, was the impetus to finally get this law passed. And then it was amended in 2014 and just made some adjustments to the original law the 603 CMR 49, if you want to, this is probably the best place to go back and look, because the regulations are a lot easier to read, and their specific directions to the school districts as to how they are to implement the anti-bullying law. And that includes, among other things, training your staff. There's supposed to be annual training of the staff, so they should know what the laws are. And the student records regulations, that has to do with student privacy. So when a school tells a parent, well, we can't tell you what happened to the other student, it's because the other student or students also have their rights to privacy. So the first thing that we need to talk about is, how do we define bullying? And a lot of times, especially when you get to middle school and there are things going on, the school will dismiss it as middle school drama. And sometimes there is such a thing as middle school drama that doesn't rise to bullying. But the statute tells us exactly what bullying is. So, first of all, it's the repeated use by one or more students. So it can be a group of students or a member of school staff. And you may know students who have experienced something along those lines. But the important thing is it is repeated use. They don't define what repeated is, but to me it's more than once. Other statutes, criminal statutes anyway, that require repetition of acts says 3. But there isn't a similar law, case law that defines what repeated means here. So I would believe that more than once. But that doesn't mean you shouldn't report it the first time, and we'll talk about that later on. It can be any kind of act. It can be written. I don't think kids really pass notes anymore, but it could be verbal name calling, or saying hurtful things to someone, or electronic expression. And that's typically what kids are doing these days. Even in elementary school, they're texting each other mean things, they're sending each other mean gifts, and that type of thing, or posting things on group chats and things like that. It can be a physical act such as pushing, which doesn't seem like a very big thing, but it's the whole totality of what's going on that makes an act or a gesture something that rises to the level of bullying. And then we talk about the effect that it has. And this is where there's a difference between like 2 kids fighting and bullying, okay? If it causes physical or emotional harm to the target, and I prefer to use the word target, fortunately the statute does as well. I don't like the word victim. So it causes physical or emotional harm to the target, or damage to the target's property. So it could be like taking a kid's backpack and like throwing it into the road, or tearing up some schoolwork that they do, or something like that. And it places the target in reasonable fear of harm to himself or herself, or damage to his or her property. Now, reasonable fear, that is defined in various cases. And reasonable fear means that the child actually is in fear, subjectively, and objectively, a reasonable person in that same position would also be in fear. So what happens sometimes when we're talking about this, when a family or a child reports bullying, is that sometimes the school will say, well, it's not reasonable fear. This person, like this kid has anxiety, and therefore they're more susceptible, they're more emotional. And they tend to use this with girls as well. Oh, you're being too emotional about this. And it creates a hostile environment at school for the target. The kid is nervous about going to school. The kid, may start to exhibit some physical symptoms. They wake up in the morning with a stomach ache or a headache, and, Mom, I don't feel like going to school. Dad, I feel sick. Or they're at school and they're starting to feel sick. It infringes on the rights of the target at school, or it disrupts the education process or the orderly operation of the school. So even if the target maybe isn't emotionally feeling threatened, because sometimes kids, especially kids with disabilities, may not realize that they are, that they're actually being bullied, but the people around them are. And that can disrupt the orderly operation of the school. So those are the requirements, the definition of bullying. So when a parent wants to know, and this is right in the statute. I took this language directly from the statute, just highlighted some of the more important ones. So, if you want to know the bullying, what the definition is, all you need to do is go to the statute, because that part is very clear. And bullying, one of the things they did in 2014 was they added that it specifically includes cyberbullying. And that helps because you'll notice one thing that is not here is it does not have to happen at school. So two other definitions that I thought needed expanding. One is retaliation, and that is any form of intimidation, reprisal, or harassment, any one of those three, directed against a person who reports bullying. So a child who reports bullying cannot be retaliated against. Provides information. What if they are the kid who was standing there when the fight started? That makes that person a witness whether they want to be or not. And they're often called into the office to explain what they saw happening. And I'm going to go into witnessing a little more later, because that's something that I ran into as a prosecutor, where people would say, well, I didn't really witness anything, but witness doesn't have to be eyewitness. So we'll talk about that a little bit more. And it can be committed by anyone, not just the initial perpetrator of the bullying. And I think the most common example of this would be that a bully is targeting another student, and the bully's friends are telling other people who witnessed it, you don't say anything. That's probably about the most common. The bully himself or herself can also be the one doing the intimidating, and I hate to say it, but occasionally it can be somebody from the school district themselves that is putting pressure on the child or the parents not to say anything or not to further pursue it. And hostile environment is a situation where bullying causes the school environment to become intimidating, or the child is worried about being picked on, insulted, or physically hurt. And I think that's what most kids are worried about when it comes to the bullying. There's the humiliation that goes along with it, but that often is the predecessor to physical harm, and we want to try and stop it before it gets to that point. And it has to be sufficiently severe or pervasive to alter the conditions of a student's education. So this means if a student is just having like an ongoing beef or argument with another child, that's probably just one aspect of school for that child. If they're on kind of equal ground and they're having an argument and it's ongoing, that might be a subject for mediation or something, but it's not bullying. If they're both on equal ground, like two friends who are no longer friends and now they're having problems, that's not bullying. We all know what bullying is. Bullying feels different than fighting. So the law is very specific about what schools are required to do. First thing is they have to develop a plan. And I would say most school districts have done this already. They have to develop the plan. It has to use evidence-based curricula, okay? So they can't just say, this is what we're gonna do, this is what our policy is. Their policy has to be using evidence, and there's lots of studies that they can work from on that. And even more importantly, Massachusetts came up with a model bullying prevention plan, and this is on DESE's website. So I found this very easily on DESE's website, 2 clicks and I was there. And they also provide, if you go to that same site, they also provide links to a lot of bullying intervention and prevention curricula. They don't mandate any one curricula, but they provide access to a number of them and best practices and that type of thing. So the school districts have access to all of this, as does everybody in the public. They have to update the plan at least every 2 years, which means the school committee has to sit down and look at the plan and make sure that it is still in compliance with the law. And they should also be looking at what are their bullying statistics and what are the outcomes of the investigations and that kind of thing. And I don't attend a lot of school committee meetings, so I don't know for sure how this is going, but they're supposed to. And they're also required to inform families and guardians. And I think they do this pretty well because they have a number of ways. The one is to post it on the district website. That is specifically required. Districts are not always told exactly how they have to do something, but in this case, they are told they have to post it on their district website, have to include it in their student handbook, and they're encouraged to provide it in other ways, such as social media and that type of thing. But these are the 2 things they absolutely have to do. Students are supposed to receive a student handbook every year, and they have to notify parents and guardians. This is as part of the plan, and it's usually in the plan. It will tell them how they can contact the DESE problem resolution system. And it's supposed to assist them in understanding the problem resolution process. I don't know how well they're doing with that. They have to provide training and professional development, and this is supposed to be on an annual basis. And it's everybody. If you look at who the statute and the regs say has to receive training, it's everyone from the teachers and the administrators who directly are interacting with students on a regular basis to paraprofessionals, custodians, bus drivers, cafeteria workers, anyone who works for the school district who witnesses bullying or potential bullying is required to report it. And they're supposed to report it directly to their principal. That's part of their training, is learning who they report it to and how they report it. But they're required to. And basically, if they see something, if an adult on the, either witnesses this or becomes aware of it, that places the school on notice. If that person does not tell anybody and something further happens, the school could be liable. So at a minimum, they have to be taught, and there are 6 things. I'm not going to read all of them off, but strategies for preventing bullying incidents, how do you effectively intervene to stop a bullying incident that you witness? This is information just like understanding the difference between what we were talking about a minute ago, the difference between a fight between 2 kids who are on equal ground and one child targeting another for bullying. They have to learn about, the research, the science behind it. They should be notified about their cyberbullying and how that can interact with what's going on at the school, and internet safety issues. I think teachers are pretty much inundated with that kind of stuff these days anyway, and they have to do this at least once a year. So it's usually, from my understanding, it is part of the professional development training that staff receives at the beginning of the school year. And as I mentioned before, any staff member who sees this or becomes aware of it has to report it to the school principal or whoever. The principal can designate a person to be in charge of this stuff. Now, here's the other thing. They have to notify parents of those policies and procedures, and they have to tell parents how to report bullying and retaliation and how it will be handled, what the school will do. And they also, if an incident of bullying happens, then they have the requirement to notify both the parents of the target, the parents of the aggressor, and notify all parties of what is our process. We have an allegation, and what is our process. And so they do this within the district policy. So the parents should be notified at the beginning of the year when or what the policies are and how the school will handle that. And then the parents will get written or verbal notification when bullying occurs.
And that's in the student handbook also?
It would be in the student handbook. The first two should be in the student handbook, okay? And I haven't run across a school district so far where I've been dealing with the bullying where it's not in the handbook. The question is, do parents pay attention to that, which is something I'm going to talk about later on. And how much do they understand of what's going on there? The school is required to conduct an investigation if somebody reports it or if they become aware of it. Okay, and they have to investigate promptly, and that usually means like right away, this minute, when it's reported. They have to take all reports of bullying and intimidation seriously, and that means even if a parent doesn't follow their procedure exactly right, the minute the school becomes aware of this, they're supposed to take action. Okay, so maybe the parent calls the guidance counselor instead of filling out the form. The school has to start taking action then. But as we've talked about it in other of our workshops, parents should put everything in writing. Even if you make a phone call, you follow up with an email and say, I reported this to so-and-so. They have to consider all of the available information known. They can't decide that they're not going to look at something else. And this is why I said earlier when we were talking about what does repeated mean, this is why I said you don't not report it the first time, okay? Because then the school can say, well, we didn't know about the first time, and it also makes it harder for them to investigate if there's something that has happened in the past. The further away from the event you get, the harder it is to make an accurate decision about what happened. So that means that even if they did not find bullying the last time or the first time that something was reported or in the past, if there are 3 other complaints about this kid or group of kids involving this student or another target, that is information that they should be considering, okay? What I find is a lot of schools are treating each incident that's reported as an individual incident, which is not what you're supposed to do. Bullying is a pattern of behavior, so they have to consider all the available information. They have to remind everybody that retaliation is prohibited, and that can all include between parents and parents. So, that's an important reminder. So there are specific steps that the statute and the regulations require for an investigation to be compliant. Obviously, the first one is to interview the target. Now, the person who is the target may be reluctant to speak, may be reluctant to speak with certain people, but the school has to try to find a way to accommodate and figure out how they can best assist the target. The target may already have been intimidated, like you better not tell anybody. They also interview the alleged aggressor, or give the alleged aggressor an opportunity to tell his or her side of the story. I'm going to talk a little bit about, there are complications to that when you're trying to interview someone who's accused. There are no due process rights written into the statute for the alleged aggressor. I found this out when a family contacted me and said, my child's been accused of bullying. What are his rights? And it's not written into the statute, but there are things that parents can ask for. Interview all of the known witnesses. This is one of the most frustrating things for parents that I've dealt with personally, is that they will tell the school all of the people who witnessed it or who may have some information, that type of thing. And then they'll get the investigation report back, if they get the investigation report back, and find out that the person investigating never talked to some of the people involved. They may interview the parents. The parents may have some background information. The school should at least ask the parents if they know anything. They should be reviewing, this is not written into the statute, this is me as a former person who had to investigate things, saying, review all the available video, including the school buildings. Most school buildings have video in the common areas, the hallways, the cafeteria, outside the building. Look at the bus video, although one caveat to that is, if it happened on the bus, the parents need to contact the bus company immediately and ask them to preserve that part of the video. Okay, I'll come back to questions when we get to the end. Okay, because bus video it gets taped over and over and over, and I contacted Lower Pioneer Valley Educational Collaborative. They provide bus services for a lot of the outlying towns, not the bigger cities, but and depending on their route and how long that particular route is and how many hours that bus is running a day, that will tell you that will shorten or lengthen the amount of time that video is available. And it can be as short as a couple of days on a very long route. So you don't want to wait on that. You want to call them immediately. Call the transportation company immediately. CC the principal on that request. Again, this should be in writing. And ask them to preserve that. It is the principal, like the bus company best practice would be to preserve that on a parent's request. But they're not required to preserve it unless the principal or some other person from the school requests it, and then they're required to try to preserve it. But again, if the principal doesn't get to it in time, then that video may be lost. So that would be my practical suggestion if bullying happens on a bus. They should also view available social media. This is one of the things that I run into a lot of times is I will say, I would like to see the video. And it might, for any number of reasons. And the answer I always get from the school is, oh, we can't do that, student privacy. And yes, they are covered by student privacy. But there are ways to, parents run into this too. There are very simple ways these days to block out the face of any student who is not directly involved in the incident, okay? I argue the alleged aggressor does not have the right to privacy when we're talking about that. You know, you don't shield the face of the kid who's pounding somebody else because they're, you know, in my opinion, that right to privacy, that's not what FERPA was intended to do, okay? But 9 times out of 10, I already know what happened, because if there's a fight in school or there's bullying that people think is very funny, then there will be social media out there, probably dozens of videos. So I've already seen that, but I want to see what the school is seeing. Consider past reported incidents, if any. That's what I was saying about you can't ignore things that have happened in the past. And consider any other relevant evidence, and that will include whether this child has a particular vulnerability, like in their IEP. Did we discuss this, where because this child has autism or anxiety or some other difference where they are particularly vulnerable. And they should be consulting, during the course of this, they should be consulting with school counselors who hopefully are providing support to the target. And services to the alleged aggressor, if that is something that is, you know, that would be necessary or useful in order to help to stop future bullying, I guess. And to the extent possible, they have to, as they're going through this, they have to maintain, excuse me, they have to maintain confidentiality. Does anyone need to take a break at this point? Or anything? No? Okay. All right, so that's what the school is required to do. And this is important. They have to maintain a written record of the investigation, and that includes everybody that they've talked to, everything that they've looked at, and what is the basis for their conclusion. They can't just say yes or no. It has to be yes or no because of the evidence, the interviews, and so forth. And finally, well, not finally, another requirement is that they need to notify the parents of the target what they've determined happened. This would be at the end of the investigation. This is what we found. This is what we're going to do to protect your child from further bullying. We have a plan, because they should come up with a plan. They can't just say, okay, yes, there was bullying that happened, and let's all move on. Let's be good. What the school will do to support the child's well-being within that school environment. And if a safety plan will be implemented. And the safety plan basically talks about how each of the parties typically will move around in the school. And it may include, for the child who is the target, it may include, you know, someone walking with them or a teacher in the hallway supervising while the kids are moving between classes. It may involve somebody in the cafeteria, keeping an eye on, being aware of what has happened. And typically, like, kids not being in private places by themselves, like, you know, the target and the aggressor should not encounter each other in the bathroom or something like that. So parents need to be notified of this. But this is the thing that upsets parents more than anything else. Do not expect the school to tell you what they are going to do in terms of discipline to the alleged aggressor. And this drives parents crazy. But they can't. This is where FERPA comes in as far as requiring confidentiality. That is a piece of information you probably feel like you have a right to, but you don't. So do not expect the school to tell you what's going to happen to the other child. But on the other hand, you will know if the child got suspended because that child won't be in school. And also, kids talk, parents talk, you're eventually going to find out what happened to the kid, just not from the school. They also have to notify the parents of the aggressor. Again, what happened, if there's going to be a safety plan implemented, what kind of discipline the school intends to take because of this. And that can include suspension, or maybe the student is not allowed to be involved in extracurriculars or things like that. And in certain circumstances, whether the school is going to notify law enforcement or another outside agency such as DCF. So this is the practical portion of the workshop. What should parents do if they're notified that their child has either been the target or is accused of bullying? First thing is, before any bullying begins, there are things that you can do to prepare yourself, prepare your child. And so the first thing is, at the beginning of the school year, like as you're starting to get their school supplies together, shop for their their clothes or whatever they need for the coming year, that's the time period where you should familiarize yourself again with what the policy is. See if it's changed. But just remind yourself, look at it again. Like I said, it's usually on the district website. And then remind your child that if someone is picking on them, first of all, that they should be able to come to you. Second of all, that they should be able to tell a trusted adult at school. And so that in a way that kind of helps you to have that in your mind already, helps your child to kind of insulate themselves a little bit and know that there are adults that they can trust. You should address your child's vulnerability to bullying with the school staff. That should happen during any IEP meeting or a 504 plan meeting. But if something happens, excuse me, that in the course of the year that you feel makes your child more vulnerable to bullying, you should notify your IEP team, your school principal, or vice principal, whoever interacts with your child more often, and the school counselor, just so that they're aware and they can kind of keep that on their radar. Discuss bullying at home, both how not to be a victim or a target, but also not to be a bully. All of us kind of worry about bullying from the point of view of our kid being picked on, but we tend not to think of our little darlings as the ones who might be picking on others. And the thing is, sometimes a child who has been bullied will turn around and bully other children because that's a learned behavior. And I've known of 2 situations where that happened, where I can definitely say this child was bullied, and then like the following year, they were bullying other kids. Or in the case, like there was one kid who was a kindergartner, first time riding a school bus, and so this kid's in kindergarten, the first and second graders were bullying him, and then not too long after that, he was accused of bullying, and he just thought, that's what that's how we behave on the bus. So, that's how if you talk about it at home, it helps them to identify when they're being bullied and how not to be one. And encourage your child, again, as with every other important topic, that they should talk to you about that immediately if something happens. So, now if your child becomes the target of bullying, the first thing you're going to want to do is throttle the person who is bullying your child, okay? But what you don't want to do, and I can say this from personal experience, my first response would be, what? What happened? You don't want to do that. Just stay calm, Sit down, ask your child those who, what, when, where, why, how questions as calmly as you can. Take notes if you need to, but and then notify the school immediately, even if you think your child told somebody, or if the child tells you that a teacher witnessed it or a paraprofessional was on the schoolyard when this happened. You notify the school yourself immediately. I usually suggest you call right away, leave a message for the principal or whoever you talk to, and follow that up with an email. Because as I'm always saying, if it's not in writing, it didn't happen. The principal can always say, oh, I didn't receive your call. But then you would follow up. This is the most important, well, not the most important thing, but a very important thing to make sure that things are done properly is to follow up by filing the form. And I have a copy of the form and both the form that the parents fill out and the response from the school that we'll look at a little later. So put that in writing. Ask who's going to be investigating. Don't just put the paperwork in and trust that something is going to happen. Find out who's going to be investigating and stay in touch with that person. We already talked about requesting that the video be preserved. And what you want to do is provide the investigator with the names of all the witnesses, exactly your understanding. This can be important. You say this happened in the schoolyard. I had one case where the aggressor was following the student around it was a middle school, so they could kind of walk anywhere on the grounds they wanted to during break time, during recess or after they finished their lunch. Followed her all over the place, but did not assault her until she was in a place where the video camera didn't reach. So you want to know the exact place so that they can't say, oh, we looked on the video and we didn't, the mom knew that this had happened in a location where there was no video. If there's going to be any physical evidence, for instance, if some of the child's property is broken, you can let them know that you have that. Anything else that you think the investigator should look at, and again, put this information in writing in an email to whoever is going to be investigating. And this is a lot of work for parents, I know that. And then request a copy of the written report of the investigation. They are not going to want to give this to you because there are going to be names of other students, potentially school workers and that type of thing. It's perfectly okay to say, you can identify these witnesses as student 1, student 2. Go ahead, redact their names. I don't need to know their names, but I want to know that you talked to, if I provided you with the name of 4 witnesses, I want to know you talked to 4 people. Again, make this request in writing. They are supposed to provide this to you within 2 weeks of when the report was filed. So just when I'm working with a family on that, if I'm involved at that level, I'm usually not. Usually people contact me after something has happened that was inappropriate. But make a note in your calendar that it's due on this day and contact them and ask for it. Because otherwise, you might never hear about it again. And as I said, follow up the day that the determination is due. So this is also on the DESE website. This is a sample bullying prevention and intervention report. Most of the districts that I have dealt with actually just took this verbatim and made it theirs, because if you take what the state provides you verbatim, then you're pretty sure you're doing things right. So this is the part that would be filled out by the parent. You can find it on the state website, but the district should provide this on their website as well. You just download it, fill it out, and send it to the school. Don't send this with your child, okay? Either hand it in personally yourself and ask for a date-stamped copy. Always keep a copy of anything you send to the school. or email it if they'll accept it by email. And so basically the top part is just, getting your information, and a student can fill this out themselves too if they're old enough and they want to. And then the second part is the details about the incident. You don't have to limit yourself to these lines here. You could always just say "see attached" and write a narrative. And then the second part is where, again, you get to list the witnesses, and you should include like any teachers or staff people that you think were there. And again, you're not limited to 3 witnesses. Put down anybody who might have some information. And then finally it asks for some details. Again, it's very easy to write "see attached" and do a narrative. So that is the part that would be the responsibility of the parent. And this is where we were talking about earlier, who is a witness? Okay, a witness is any person who has information about an event. Sometimes people genuinely think they're not a witness because they weren't an eyewitness. And sometimes people try to get out of being involved by saying they didn't see anything. A witness does not have to be an eyewitness to an event. And an eyewitness doesn't have to see the entire event like they might say, well, I just walked into it. I didn't see the beginning. They don't have to see the whole thing in order to be a reliable witness. A witness might be someone who has information about something that happened before. Maybe a witness is a teacher who didn't see an incident that happened in the hallway, but was aware that there was some tension between the two. And I've been talking about 2 people because that keeps it simple, but we all know bullying can involve multiple people, and we'll talk about that in a minute. So a teacher might not have witnessed it, but still might have some information that could be helpful. A witness might be somebody that the aggressor went and talked to afterwards, and maybe bragged about what they did. They go to the next class and go, I just kicked the what out of so and so. Well, those people didn't witness it, but they still heard the aggressor admit that they did it. And witnesses can perceive information through senses other than sight. You might hear something as opposed to actually seeing it. You might hear like a punch land or a slap or something like that, even if you didn't actually see what happened. And smell is another sense that can be used. For instance, excuse me, this is not specifically relevant to bullying, but for instance, if a child was accused of, say, vaping marijuana in the bathroom, and a witness nearby was like, I didn't smell anything, or I did smell something, that would be a time of where smell would be another one. Now, if your child becomes the alleged aggressor, then you take a different approach. Again, you want to stay calm, listen to the person who's telling you this, and it's usually not going to be your child. It's usually going to be a principal or a vice principal or maybe a school counselor. So I suggest that people take notes when they're talking to the counselor or the principal. And then, again, as calmly as you are able, talk to your child, get your child's side of the story. I also recommend querying your child's side of the story. Don't just don't just accept right off the bat that the child is telling you the absolute truth. Kids who are afraid of getting in trouble may not tell you the absolute truth. So think about what they're saying and ask further questions. Ask your child who witnessed the event, because you want to provide evidence to the school as well. So ask the child who else was involved. Who else was around? Did you talk to anybody about this? Advise the school and tell them this right off the bat when they call you. that you don't want your child being interviewed outside of your presence, and then follow that up in writing. Like I said, there's nothing written in the law that says that the school can't interview your child without your permission. But if you tell them you don't want them interviewed outside of your presence, then they generally will abide by that. Advise your child not to discuss the incident with anyone, not even their friends. And again, you want to find out who's going to be investigating so that you can stay in touch with them and provide them with information. You should also be requesting, if there's a possibility that there's video, that it be preserved, because it might help your child's point of view. Provide the investigator with any evidence that you want them to consider that might not already have been provided. And again, provide it in writing. And then just like if you were on the other side of the incident, you want to request a written record of the investigation, making that request in writing. You want to know what's going on, and make sure that it's by the day that the investigation is due. So those are the things I would do as a parent if your child is accused of being the aggressor in that situation. Now, this is what the investigator is going to fill out. It's actually the second page of the same form that the parent sends, at least in the sample document. And you can see, they have to identify who they are, what their position is, and all the steps that they took. Like, who did you witness, or who did you interview? I didn't want to use the word interrogate. Who did you interview? And again, they can use more if they interviewed more than 4 people. This is the important thing, or an important thing. Number 3 says, are there any prior documented incidents by this aggressor? So that is a sign to them that they need to be looking back into the aggressor's record, and also looking at, did it involve this target, or it says, or target group previously. So it may not be the same target every time, but for instance, maybe this kid has a problem with kids who have autism, or kids who look different. Maybe this kid is always bullying the kid in the wheelchair, or the group of kids who are in the special ed class, in the sub-separate class. So they need to look at that and any previous incidents with findings of bullying or retaliation. Now, the fact that they are not there doesn't mean there's no bullying. It's like a reminder that you can't just consider this immediate incident. And then they do a written summary of the investigation. And really, it should take more than that, third of a page that they've got for it there. But and then they document that they've either found bullying and retaliation or they didn't. And sometimes even if even if an incident isn't found to be bullying, it can still be subject to discipline, because if one kid hits another one, that even if it's not bullying, that is still a violation of the school handbook. So, and then what are the actions taken? That may be redacted if the report is sent, or when the report is sent to the parent of the target, because, as I said, the school's not supposed to disclose that to them. Safety plan will usually be written up as a separate document, but that's, again, just a reminder to the school that even if you don't find bullying, you may find the need for a safety plan involving these individuals. And it's supposed to be signed and dated by the person who conducted the investigation. And The reports are supposed to be forwarded to the superintendent because the superintendent has some reporting to do at the end of the school year about bullying. So, any way you look at it, somebody is going to be dissatisfied probably with the school's result, whether it's they find no bullying and the target family is upset, or they do find bullying and the aggressor's family feels that it's not, that it doesn't rise to that level. Now, if this is a first incident, remember that that finding of bullying requires repeated instances under the law. So if you file on a first instance, you can probably expect that the school is going to find no bullying because of that. That does not mean that this is a failure, okay? You file that knowing that you are creating a record for future incidents that hopefully will never happen. But you're creating a record here, and you go into it with the first instance knowing that you're probably going to come away with a finding of no bullying. So you basically take that and you walk with it. You keep a copy of everything. Document everything, but you went into this knowing that this is probably going to be no bullying. If it's a second or later incident, where you feel that this met all of those statutory and regulatory requirements for a finding of bullying and the school didn't do it, didn't find bullying, or the school missed some steps in the investigation, then you can file a complaint with the problem resolution system. Now, the PRS system in Massachusetts has been extremely overwhelmed. They, in fact, were recently, well, not that recently. Toward the end of the Biden administration, there was an investigation. The finding came out after the current administration came in. So a little over a year ago, there was a finding that the PRS system was not operating the way that it should, and it was taking way too long for findings to come out. I had a couple that were over a year. We were waiting for a decision, which is well beyond their deadlines. So they've been working very hard on that, but unfortunately what they've been doing is they've been meeting their deadlines on the new things that are being filed and trying to work on the backlog at the same time. So if you file now, you probably have a better chance of having it completed within the timeline, but still, you can't really count on that timeline. It can take a long time, and it can be very dissatisfying because their decision when they come back on a subject like this is very often provide more training to the school district. They about bullying and so on and so forth. So they have to prove that they did another professional development. That's typically what I've been seeing. If your child has a disability, though, or if the bullying might constitute discrimination under Title IX, which means sexual harassment, sexual abuse, or creating a hostile environment based on gender or gender identity, or anything that falls under Title IX, then you can file what's referred to as a Gebser letter, Gebser. You can, if you type that in, Gebser letter, into a Google search, it will come up immediately. It's named after a 1998 Supreme Court discrimination case, and it puts the district on notice of a possible federal lawsuit based on deliberate indifference. Deliberate indifference is the standard that has to be shown to prove a Title IX case, and in some cases, a disability case under, say, the Americans with Disabilities Act. So and it's very strongly worded. You can find many sample Gebser letters online. I have one, so if you needed to, you could just email me and I can send you a sample one. Obviously, you'd have to plug in your own facts, but it's a very strongly worded letter that says, I think you have been deliberately indifferent to the harm that my child is facing. And I will tell you, I recently had a case with a local school district where I felt very strongly that that's what was going on. We did the PRS. That's the other thing, though. If you want to bring cases outside of the school, outside of DESE, most often you will have to exhaust all of your remedies that are available to you within the school or the education hierarchy. Okay, so that means if your remedy was to file a complaint with the BSEA, the Board of Special Education Appeals, and you didn't do that, you jumped straight to a lawsuit, it could, under many circumstances, it could get kicked out because you didn't do everything you were supposed to do here. So you first file a PRS complaint and wait for that result to come back. And then you could go and talk to an attorney about a case of deliberate indifference. And I have recently referred a case out like that. I don't have the capacity to handle a federal discrimination case, but I can refer it out to someone that I believe does a good job. So that is like your big step to take if you're not happy. So that's the main presentation that I had. I just wanted to talk about a couple of instances in case I haven't touched on it. I think we have, though, talked about the school saying or not looking at all of the circumstances and treating each individual incident as a separate incident and therefore not rising to the level of bullying. So that's something where the parents have to push back and say, no, this has been happening with my child, or I'm aware that there's been a bullying investigation involving this aggressor in the past, and so you need to push back on that. The other thing often is that it doesn't have to be a single person against a single person. Very often, bullying involves multiple people picking on one person or picking on a group of people. It might be that originally your child is the first target, and then your child's friends also become targeted. So that's one reason that it's important for parents to talk to each other so that you're aware of that. And that's another area where other people, when we're talking about witnesses, people who have knowledge may not be an eyewitness, but yes, I have seen him pick on Joey multiple times. Like, we've been having lunch together, and I have seen him pick on Joey many, many times. The other thing is that bullying can grow from one aggressor to a group of aggressors. In one case that I had, in fact, it was the one I talked about where the assault happened outside of the video, outside of where a video would catch. That was two individuals, one individual targeting one individual. But then what happened is the aggressor's boyfriend got involved. And then the aggressor's boyfriend's friends became like a gang of people who were on the target. They were texting, intimidating her in class, a number of things, but they were doing that as a group. It wasn't always one individual person that was doing it, although there was, the boyfriend kind of became the center of the whole thing. But the parents were able to report the names of this group of children, middle schoolers who were picking on one another. So that's something to be aware of. So sometimes it might be aggressor A does the first thing, and then aggressor A's friend, aggressor B, does something else, and then aggressor C does something else. Those are three individual and separate events, but they're all part of a pattern of bullying, and that is what schools are supposed to be looking at. And because once you get to that point where there's like a horde of people picking on another person or another group of people, that really affects the culture of the school. And it can affect other kids who see this, who are not even involved, but that can make other kids unwilling to come to school or to have a hard time learning in the classroom environment. It just kind of infects the whole school. And so we want to, as a parent, we want to keep our individual children safe. And so we have to deal with that. But we also want to encourage the school to be taking these important positive steps in order to make for a better culture within the school so that all the kids can learn. You know, because there could be and probably are a lot of collateral consequences to witnessing bullying. So that's why I think this is such an important topic. And if you have any questions for confidentiality and privacy, we will turn off the video at this point.